where we're going to have some practitioners share their perspective. We're going to try to have the practitioners chat for about 15 minutes or so, and that will give us 15 minutes at the end for this great conversation here. We have Laurie, Webb, Daniel, and Kathryn Powers who are going to go ahead and share their thoughts with us now, and I'm going to turn it over to Laurie to get us started.
Okay, great. Well, it's great to see everybody here, and it's fun to be back at Mercer. Last time I was here was about a year ago. It was November a year ago, and I was arguing an appeal before the Georgia Supreme Court, which was holding a special session here at Mercer because the chief judge is an alumnus, and it was really cool. Came down, and they were TV cameras and everything, and then, the argument actually was a little bit intense. But I left afterwards, went back up to Atlanta, and I heard from one of the justices later that we were on TV, and the TV reported that I was participating in a mock trial that the Supreme Court was holding at Mercer Law School. And he was cracking up on me because there was nothing mock about that. But anyway, it is good to be back. And I love the facilities here. It's a great law school. So I'm really pleased to be invited to participate in this program. So I'm just going to share, perspectives, just some, anecdotal stuff, and just thoughts on legal writing and how to train for legal writing. Doing it as a professional, and from my experience, I do remember very well my research and writing course at law school, which it was fine, but it was not the most memorable experience of my life. As it turns out, I became an appellate specialist. Okay, so writing is what I do, and I end up traveling a lot these days, it seems like. And I remember being on a plane not too long ago, and the person next to me asked what I do, and I said, well, I'm a writer. They were really interested, and as soon as I said I was a lawyer, did legal writing, it's like they didn't want to hear about it. I said, hey, wait a minute, because what I do is real writing. I have to make it interesting. That's one of my number one points I tell my lawyers in my firm. You can't be boring, you got to keep the attention. Your audience, you've got their attention for a little bit, but this is not the only case they have. They've got piles and piles of things they have to go through, so do not be boring. Let me back up though a little bit and talk about becoming a writer, becoming a legal writer, and I'll just share some of my experiences, so where I'm coming from and how it evolved. I certainly, when I was a law student, was not expecting to be an appellate specialist. I was just kind of going along, trying to figure out what to do. I actually went to University of Oregon School of Law. I was interested in being an admiralty lawyer. I like those, they a little international law, a little contract, a little tort, federal court, makes it easy, I ended up, though, moving back to Atlanta after the second year of law school and going into a litigation boutique firm. So I was there, and actually my dad, it was a firm my dad started, and Dad was a great trial lawyer. He hated appeals. If he won a case, he didn't want to think about possibly losing it later. If he lost the case, he didn't want to think about it, period. So he started handing over all of his appellate work to me. So I soon became kind of the law person on the cases, and it was a litigation boutique firm, very high end, and so I realized this was a good niche for me. It felt good, and one day, and I remember the day it happened. I was a somewhat young lawyer. I decided I want to be an appellate specialist. That's what I want to be known for. And at that point, I really started making it my focus to be a person who would be known for excellence in the skills of an appellate advocate, which are primarily written work. You get a 15-minute argument in the 11th Circuit Court of Appeals, and so you really need to make sure you've got your point across in writing. So at that point, I really started focusing on what I think you guys are focusing on now with your students, in law school, but I didn't have it as intense at that point. How to refine the written advocacy, how to improve on that. So I pretty much engaged on a very intentional course of continuing legal education. I'll just put it that way. I sought out all of the writing workshops that would come through Atlanta. Brian Garner wasn't on the scene back then, but there were others that came through. And I would go to them all because I realized that the professors who were, and they were mostly law professors who were holding these workshops, they had different perspectives, and I learned, some from one, some from another. I got the, the Strunk and Dwight back out and actually reread it and started, applying it. I started spending a lot of time just editing and revising, editing and revising. And I think that's unusual. I don't know very many associates that do that, and I just did it sort of instinctively because I realized that it was what I wanted my identity to be. I was still in a little firm, but I was developing and enjoying this role as the law person and the person who did the motions, did the written work on these cases. They're big cases. I was getting, because of that, some experience in really kind of fun cases in front of the Georgia Court of Appeals, 11th Circuit. Actually did get up in front of the U.S. Supreme Court, wrote a petition for cert, which was granted. And yeah, I mean, that's not easy. So I was continuing to do that, and then in about 20 years ago, our firm merged into a big firm. We merged into Holland Knight, which was at the time the largest firm in Florida. It had not yet expanded. It's now a national firm. But when I merged into Holland Knight, I realized they recognized appellate as a specialty, as really a special practice area. In fact, the Florida bar at that time already had an appellate practice section of the bar. And the head of the appellate team was a former appellate judge, Florida State Court appellate judge named Dan Pearson. He was a fabulous guy. Dan was strict, and the culture there was that the trial lawyers sent their appeals to the appellate group. The firm had a policy that every appeal had to involve one of the appellate specialists, and there was really a great team of lawyers. So again, the culture was involving lawyers who really had a focus on appellate advocacy, which means you've got to get the point across, soon, quickly, easily, and all of the that goes along with that. Eventually, I ended up becoming chair of that appellate practice team when Dan moved to Washington and had an appointment there. And at that point, I think when I got to the point where I was trying to manage the appellate team, the firm was growing, and that culture of strong focus on appellate was becoming somewhat diluted because we were bringing in offices from other jurisdictions. It became a challenge for me because then the question for me was, how do we train our lawyers? We would have lawyers who didn't have this expectation in the real world, and it's not just associates. I mean, we had partners and who just didn't have that particular focus. So I've gone back and tried to, and we have some training programs for our associates. So that's one thing that we are trying to do, to make sure that people understand the importance, the absolute critical importance of writing to our profession, and in particular, motions practice and appeals. So in a way, I'm learning from you guys today already. And one of the important things, just following up on the discussion you had with the judge, constructive criticism. I mean, that was just tremendous to hear. The value of getting together a group and having this kind of discussion is, and of course, my friends who write novels for a living, they have reading groups. I mean, of course, that's what you need to do. So if you can get people accustomed to that, that's the biggest challenge I have, is getting the attitude and the mindset. So I would absolutely echo the value of doing that, and it's something that I haven't tried it in a group setting, but I think that's an excellent thought. Started off early. I loved hearing about the resilience. Absolutely, and I want to echo the civility, point she made. And going back to Dan Pearson, who was my mentor, he said his goal was not just professionalism, it was quality control, and it was to the point where if a judge were to pick up a Holland Knight brief, they wanted to know from the cover, from the beginning, from the cover, that it was reliable, credible, and was going to be a quality product. So that's kind of a goal for our training. We're still trying to work it out too, so again, I really appreciate being here and hearing what others have to say on the subject.
Thank you so much. We're going to save our questions until we've heard all of the panelists. So, Kathryn, I'm going to turn it over to you.
Good morning. I'm used to standing, so I'm going to stand up and talk to you all this morning. Typically, it's at a phase of 12 folks who may or may not be enjoying what we have to say. But so it's a little bit friendlier this morning. My name is Kathryn Powers. I was fortunate to graduate here at Mercer Law School back in 2009. I'm currently with the Clayton County District Attorney's Office. For those of you not from the area, if you flew into Hartsfield-Jackson International, you came through Clayton County. Started well after Judge Colvin did, obviously. But so we're a Metro Atlanta Prosecutor's Office. I want to talk to you a little bit about, I came straight out of law school to that office. Currently I'm in charge of our homicide division there, but I also get to supervise our new trial attorneys as well as our internship program. So I want to talk to you about some of the things I experienced and then some of what we see when the interns and the brand new lawyers come into the office thinking that it's law and order and not some of the nuts and bolts that typically occur within. So to kind of give you a little bit of background, I took the bar on a Tuesday and Wednesday. The new district attorney had actually been elected in January of that year, and it was quite an influx office. And I say that to say that we didn't have really a whole lot of people to kind of go to because everybody was going in one direction. Some people were going out the door, some people were coming in. So we had to rely on the tools that we had. I started with 2 other Mercer grads. We took the bar on a Wednesday and were sworn in that Monday, and essentially said, here's your office and here's your caseload. So when we went to court, there were things that the judge would say, well, I'm sure the state will submit an order on that. And you're standing there going, oh, okay, I guess the state will. The state will figure that out. I had the advantage of going through our advanced legal writing program, and I had all 3 of the professors who were hosting us say, I'll brag a little bit about that. So I felt better prepared than some of the other folks who started. But one of the things that I didn't really have the benefit of are some of the alternative pleadings. And I know you guys are limited. I know, it's memo and brief, and you're certainly limited about what you can arrange or do from that manner. But I had no clue how to draft a motion. I had limited clue on how to draft an order, especially one that the judge was going to sign off and defense counsel would agree, oh yeah, no, that's a neutral order. So those were all learning experiences, and I think some of those practical, and I know certainly you can't have that for every situation that occurs, but some of maybe the more broad things are helpful in that practical application. Also, we draft our own indictments. So when we're drafting charging documents, I was Thinking, all right, well, I hope this is right. And a couple of times it has not been. And we've suffered the consequences of that. So some of those practical applications, and I know that's different from your students who go into civil practice or who go strictly to appellate work. Thankfully, now we have an appellate division. I went to speak to our deputy chief about some of the things she sees, and she kind of describes her job, for lack of a better term, as cleaning up after the circus elephants and gone through with the trial about some of the precedents we've left for her. So some of those practical aspects, though, or most of what we do is justifying what's already been done in a written form. So some of the things that are helpful, that I would have found helpful, is some of those alternative pleadings, or at least having a resource or an ability to reach out and call a phone a friend, for lack of a better term. Some of those helps, some of that assistance. One of the things that we tell some of our new lawyers and our interns is that there are 3 reactions that a judge has when you walk in the back of the courtroom. Thank goodness they're here. Man, I wish they weren't here today. Or who is that? We tell them we don't want them to fall into the latter categories. We want to be making it easy on the judge. One of the things that when they come out of law school, they've maybe been exposed to potentially 2 standards of review that they write about. One that they're exposed to in the memo that they've gone and they've researched, and one maybe that they have in their appellate brief. One of the things that translates, I think, in trial work as well as appellate work is understanding those standards of review. So if at all that can be incorporated with the list and the different types of evidence and things of that nature, it makes it a lot easier to walk in and really make the job easy on the judge. One of the things we're also finding with especially the new lawyers is the inability to concede. They think that they have to argue on every point, and there are sometimes you have just screwed up, or the law is certainly not on your side. And you found that case, and there's not going to be a magical one that says that you're going to be okay. So it's typically the inability to concede and realize perhaps there's another remedy for you. Perhaps there's a separate way that we can get this evidence in, or maybe it wasn't prejudicial. So a lot of times with especially our second-year interns, it's the inability to concede this point. It's okay. We don't have to argue about everything. So that's one of the things that we've seen, and you know that it's uncomfortable for them. It's still uncomfortable for me, I don't like to concede. But it's an uncomfortable situation for them, and what they're not really learning or necessarily really applying are alternative remedies, like we've talked about, or alternative ways that they can still succeed, whether it's at trial or on the appellate level. So those are some of the skills that they are not demonstrating necessarily when they come out and they come to that trial setting. We try and make it as an environment that's not soul-crushing for the feedback and the constructive criticism, but a lot of the times, and I know you guys have externships, they are reluctant to come to us. You know, I mean, I've added a candy dish in my office to try to make it a little more inviting. Out of Starburst, let's talk about how you screwed up. So that constructive feedback is something we're working on too, but some of those nuts and bolts that may translate from different areas of practice, and not just in the criminal world and in the civil world, would be some of the standards review and things that they're not comfortable with. I went down and talked to our chief judge before coming down here because, quite honestly, now that we have an appellate division, I do a little bit of limited writing, more oral arguments about what she's already written. And the judge says what she sees a lot of is simply lawyers who are sloppy. And I know that's not certainly a skill that you're teaching. We understand that. But the citations, the page numbers, the one case instead of multiple cases, or distinguishing other authority. And I know that's certainly a skill that's being taught, but that's something that we're seeing still lacking when they're making that transition. The ability to distinguish a case, to explain, or to expound. They can find the case that supports their point all day long. That is not a skill that they lack, but it's the ability to explain or distinguish opposing authority, or the opposing counsel's authority as well. So those are some of the nuts and bolts that we're seeing when they come in. One of the other things is honestly time management. You know, we came from, and I know most of you have an entire semester to write a brief. and you don't have, you might have your finals at the end, that sort of thing, but you don't have 500 cases staring at you at your office when you're having to write multiple briefs. So maybe those multiple assignments over the course of the time, the time management skills are something we're finding. When they have a deadline, obviously, that the court has imposed, they certainly are required to follow that. But those are some of the things that we're seeing. Their oral skills, they of course don't believe are lacking, but it's the beginnings and those foundation stages that they're wanting to skip over, the written work and the research and things like that, because they all want to be in a courtroom. And what they don't realize until they've been there a few months is how much we have to work on the back end. When I arrived, I had an advanced legal writing course, like I mentioned, and honestly, I think it needs to be more than 1 credit. I think it's one of the most helpful classes that I had in law school, because it provides that feedback and that foundation. So for those of you who don't have it at your law schools, I think it's fabulous. Obviously, I know that's typically a dean determination and things like that, but I think it's certainly fabulous, and it allows you to have, we have to turn in a writing portfolio, so I was able to go back and kind of flip through, okay, I addressed that at one point. I had one order that we were required to write and kind of go back and use that as a template during a time of flux at our office. So I certainly look forward to answering any questions that you guys have at the end.
Thank you so much. Dwight?
Well, obviously, the most important thing for young lawyers is to learn promptness. I'm going to speak on that. No, I apologize to everybody. I had it on my calendar at 10:30. I think I'd seen an earlier agenda that had a break from 10:15. Anyway, that's my excuse. I apologize. I was luckily pulling into the parking lot when I got your helpful call that I was late. I've been rewarded by being late, by getting to go third, so I can riff on some of the things that others have said. And I was struck a little bit, Laurie, your comment about how you knew the direction you wanted to go after you got out of law school and then focused on that. And I was thinking, I pretty much did the same thing. I guess I knew earlier that I really wanted to be a trial lawyer. And so I did start directing myself in that way in law school and taking all the advocacy courses I could and get every opportunity to stand up. But I chose, after graduating from Mercer Law School in 1982, I got to go with a really large law firm, King & Spalding, that was at the time the largest law firm in Atlanta. It still may have one of the largest offices in Atlanta, and we're spread out all over the world now, as Holland Knight has done, kind of spreading around. And of course, as I was being recruited at different law firms, kind of the dirty rush on big law firms was, if you go there, you're going to be thrown into the library, you're going to be a stand-up lawyer. You need to get out, get into the courtroom more. And if you come to a smaller firm, you'll have more of those opportunities, which is a good selling point for a smaller firm. It's actually a much better selling point for a district attorney's office. I tell young people, if you really want to get a grounding in trial work, that going to a prosecutor's office is obviously the best choice. But so knowing I wanted to be a trial lawyer, knowing I was going into an area of practice that where I wanted to be a trial lawyer, and at a law firm where they say you will never get in court, I said I'm going to find the path to do this. How can I get into court more often? And like Laurie, I started seeking out all the trial practice courses that I could take. The firm was very generous at those days about sending you to seminars, and I went to the Emory NETA program that they hosted the Atlanta Bar Association, a week-long program, still one of the most valuable trial practice experiences I had, and did that. And then inside my organization, I started looking for every opportunity that I could get on the team that was going to trial. If they were extended and summary judgment has been denied, this case has been dragging on for 5 years, and all of a sudden, boom, it's just been put on a trial calendar, I would move heaven and earth and probably adversely affect my health and getting onto those teams. I'd say, okay, you're going to court, I'm going to go do that. And that's the same advice I give to young people today is you've got to look for every opportunity you can to get in there. But I'm thinking about this audience and talking to people about that are in the legal education business, and I would like to say a few things about this. First, I hope you will take some comfort in knowing this is not a new issue, that in 1982, people were talking about, you know, if you graduate from law school and you're not competent to do anything. And I was really blessed in so many ways in my experience here at Mercer, but one of the sidelights was that there was a senior trial lawyer here in town named John James, who my best friend clerked for. I didn't clerk for, I was on law review and slams, but my friend did. But a lot of Saturdays I would go over and talk to Mr. James about practice, and he's a personal injury lawyer, very successful here in town. And he said something that struck me at the time, even at that young age, about that seemed unusual. And he said, "You're not really going to be a stand-up trial lawyer until you have practiced for 5 years. You know, nobody comes out of law school and can jump right in and try cases regularly." And what struck me as unusual about that was, I thought that if I went to law school and I passed the bar, and the bar is saying you're ready to represent people in court, and the public is being told that I'm ready to represent people in court, what in the world? I was just saying I'm not going to be ready to do it for 5 years. So that kind of stuck in the back, in the back of my mind. It was in the forefront of my mind that I said I've got 5 years, and I was going to beat that. I was going to get better faster, and a little bit of pride. I tell you that I graduated in 1982. 1984, I tried 4 jury trials. That was more jury trials than anybody else at King's Falls tried in 1984. I was pretty proud of it. I worked hard to do that, but I got in those positions, and I did that. So I just go back to say, this is not a new issue, and I thought, okay, well, what's kind of changing? Well, one thing, I'm a practitioner in residence here at Mercer. I retired from King's Falls 2 years ago, doing various other things. I teach a couple of courses here, and I talk with faculty members and everything. But one of the things that I'm trying to observe the legal education and the profession and talk from time to time, and that is the dramatic drop-off in the hiring of new lawyers at larger law firms. And I'd be interested, Laurie, we can talk about that. I bet our experience is somewhat similar. I graduated from here in 1982. King's Falls I was the 115th lawyer that was hired. And our summer class, my summer class had 16 lawyers in Atlanta. King's Falls is now bumping up against 1,000 lawyers, and we're all over the country. The Atlanta office has got 485 lawyers in it, and last year's summer class was 12. The summer before that was 8. So they say they're making some, but it's actually smaller now than it was when we were hiring over 10% of the people. So what is that ripple down effect? Is they're not being hired in, and there has always been this implicit, if not explicit, understanding that we know that 3 years of law school is not enough, and you're not going to be qualified. Hence, Mr. James telling me that it would take 5 years before you could be a qualified trial lawyer. And the law firms took it upon themselves to say, okay, we're going to be a part of the training process. King's Falls got, I think one time, the last time I remember looking at the budget, we have a budget of something like $750,000 worldwide offices for associate training. That's kind of a recognition that they need more specific skills. Well, they need more skills maybe, but they need more specific skills in their chosen practice area. And that's dropping off. That's not there anymore. It's much more as many people. And I also had friends at smaller firms that would tell me they didn't hire first-year law students at the time because they knew they were going to get a look at them 2 years from now when they wash out of King's Falls, or wash out, or decide that they wanted to have a life maybe and would leave King's Falls. Kind of on a brighter side of that, I have friends in Savannah, Columbus, smaller cities in Georgia that say they are getting looks at law students now that they've never got a look at before, people in the top 5% of their class and things like that, just because they're not being hired by the larger law firms. So that's something I think why there is focus. Well, I guess one other sidelight I would tell you, you've heard this, and this has happened with one of my large clients at King's Falls. They say, I don't want first-year students or first-year lawyers on my cases. Now, a few months ago, I addressed the faculty here at Mercer, and this is probably harsher than it should be, but I said, maybe the law school should take that as the marketplace rejecting their product. They're saying, we don't think they're trained when they get out, and we don't want to pay to train them once they get in there. So maybe that's why there's this new emphasis on the law schools having to step up and do more focus on that. Just one other thought kind of that flitters in on this is, if you have not read the book Outliers, I would recommend it to you. Malcolm Gladwell, and God knows there's lots of things to criticize him, and he's picked at around the edges and everything, but the gist of that book is he looked at who becomes extremely successful in various fields. Everything he talks about Bill Gates to the Beatles. But one of the things that he noticed, and it's kind of been picked up, and maybe he picked it up with somebody else, I really don't know, but this idea that early in your career, you have got to spend 10,000 intensive hours working on everything. It was funny, it struck him the same thing. You know the legend, Beatles playing in Hamburg. You know, they were playing 3 sets a night and having to write songs, but that was their 10,000 hours that they put in the profession. Bill Gates had this opportunity to work at a high school, and then he looked back and says, I'll be darned, it was like 10,000 hours. Well, I've gone back and looked, and again, this sounds kind of hurtful to say this, but I mean, the idea that a really successful young associate at King & Spalding is probably cranking out about 2,500 hours a year, billable hours. That's very hard work. I mean, I think back and think, oh my God, did I really do that? No, it's hard work. But think back to what Mr. James told me, 5 years, 2,500 hours, you know, you're going to do that. So I know the audience here at the law school, I have 2 thoughts for you on law school curriculum. How can you make better practice-ready lawyers? One is, I really go against this idea that we're going to cut back law schools to 2 years. I think you've got to make the 3 years much more intensive. Everybody, the cliche, you work to death, you know, they scare you to death, work you to death, and bore you to death. That's got to go, man. I mean, you need, that 3rd year has got to be as intensive, if not more intensive. But at that time, maybe you'd have even somebody that has a career path like Laurie that wanted to be an appellate lawyer. They could focus on that the 3rd year. I could focus on trial work. You could focus on prosecuting if you want to. The second thing is, we all recognize, everybody recognizes the majority of lawyers' work is writing. And it really is kind of stunning to me. It was, even at the time, it was kind of stunning to me that most of our work was this crammed in 2 hours, writing as fast as you could. You know, I guess they were writing as fast as they can in an exam. But we had really good, even then, and we still have a very good writing program here at Mercer. But writing ought to be incorporated into every course you can. I taught an advanced civil procedure class action class here, and I'm going to teach again trial practice. But I made a point that I was going to put writing requirements in, because this feedback idea can underestimate the importance of it. How much it would be helpful to them to make him write something down and then get feedback on it, because that's what's going to that makes the difference between somebody that a young lawyer that I did think was practice ready and a lawyer that really wasn't, because they just had not had enough writing experience. So those are my thoughts.
Well, thank you for the 3. We're now going to open it up for some questions, and I just want to get us started on a question. I know that each of you touched on this on various ways in your comments, but if you're thinking back upon getting ready for that first job post-law school graduation, was there a specific experience that you had that you feel made you better prepared for that first job? And if not, is there a specific experience that you wish you had had before you had that first job post-law school graduation?
Well, I'll give the non-answer, you know, which is, I think, demonstrated by, I think I mentioned my shift. I mean, I actually had an offer to go with the admiralty firm for the summer after my 2nd year of law school, which is what I thought I wanted to do when my dad said I could come back and clerk for his firm that summer, and I thought it was just for the summer. I ended up getting married at the end of the summer, finishing at Emory. But anyway, this ties in with the resilience point, and I think, you know, in law and in life, you have to you have to be ready to adjust. Trial lawyers have to, think on their feet. Same with appellate lawyers, same with any lawyer. And so my answer is it wasn't a course I took in law school, but it was something that it actually occurred in law school, and that is the ability to shift, to be prepared to receive new thoughts, new ideas, new direction, and consider it and go with it if you need to. It's not exactly the answer.
I guess I'll start to sound a little bit like a broken record, but in our advanced writing class, we were able to pick an assignment or a written assignment at the end of the course that we wanted to write and prepare and then have it edited. And that kind of allowed everyone who maybe knew, I know a lot of students don't know what they want to do when they get out, but if they generally have an idea, it allowed you to practice at something that you thought was going to be relevant to where you were headed. I thought that was very beneficial, especially getting feedback and kind of having at least some sort of a baseline idea of a document that could be used. Kind of piggybacks about what Mr. Davis was saying about some of the ability, maybe in that third year, to be able to spread out, whether it's appellate specialist, trial advocacy, or something along those lines. So I thought that was particularly helpful.
As I said, I think fairly early on, I knew that I wanted to be a trial lawyer, but I would be remiss if I did not have a shout out to Manly Brown, is a kind of a legend and lore here at the Mercer Law School. He taught a trial practice program here that I took, and I honestly I did not know or appreciate it at the time. He kept hammering on this, you've got to do this trial notebook. And it's so simple. Okay, you can have a notebook, you've got dividers, everything like this. What I didn't realize until well later on in my career, I guess I got to the stage, if you're a trial lawyer, you've got to be to this idea about being flexible. So many times in our practices that the case was going for 4 years, they denied summary judgment, and then they would kind of look around and nobody on the team had ever tried a case. So honestly, one time I got a call on the 7th day of May, and they said, can you jump in and try this case? And I said, sure, when's it going to be? Start opening argument May 31st. And this was a $60 million case in the Southern District of New York. Back to my point on the trial notebook, I knew that if I got that notebook, and I knew everything that I had to have, this swirling maelstrom, your hair's on fire back when I had hair, and everything else is going crazy, I had that notebook. And it gave me courage to charge it, and maybe in times when I shouldn't have charged it. But nonetheless, I said I'd be remiss if I didn't say that about Manly Brown, and I pass that on now to my trial practice class also.
Well, and with that, I'm just going to open it up to the floor for some other questions.
So I have a question that's been on my mind, and that is what you mentioned, Kathryn, that traditionally, some of it's changing in legal education, traditionally in the legal writing program, first semester you write the memo, second semester you write the brief. Is there any use to the memo?
Not in my situation, no. I've had students draft a memo, but we are moving so quickly with our volume, and it's obviously different from different practices. We're moving so quickly at a volume. At one point, I did think someone was maybe teasing when they said, well, I can write you a memo. So we don't have time. We're back in 45 minutes. How about you go ahead and orally tell me? I don't think this lengthy memo is necessarily completely helpful or useful in our situation. I will say the skill and the ability to evaluate something, the skills that you learn from the writing of it, perhaps, but the actual format, no. I don't find it in my practice.
That's a very good point. In my career, I saw the diminishing use of memos. I mean, clients, the price pressure on things has gotten where it's just really rare that a client will say, well, send me a thorough memo on that. Just not going to have it. But I still think it's a valuable thought process. It's like a good training.
And let me follow up, and then I know another question on that. I have a different perspective. As the law person on some very complex cases, one of the things I've done throughout my career is not just handle the appeals, but I think the best use of an appellate lawyer is get them on board early from day one. And so often, if we have a complex commercial case, something that's got multiple issues, whether I'm on the plaintiff side or the defense side, I'll be looking ahead and seeing what I think issues are going to come along, through the course of the litigation all the way through. And I need to, I really want to make sure issues are preserved. And the biggest challenge I have as an appellate lawyer is facing failure to preserve arguments. So procedurally and substantively, if there's a new case that comes in, I identify these issues. I like to have an associate. I delegate some research and analysis, and sometimes it'll go into that notebook. I do echo the notebook. I love the notebook. But it will be in there, and sometimes it'll sit on the shelf for a year or two even. But when time comes up, you update it, and there it is. It's a packaged product. It's just a difference in the type of practice that we have. But I do think there is a place for that, and a well-written memo is extraordinarily valuable. And in the long run, I think it is worth it for the client. If it's just a rambling, whatever, then that's also a part of writing.
Yeah, I was going to say something similar. I was in private practice for about 10 years, and I had an environmental practice, and you deal with some pretty complex issues. And I think it depends on the complexity. But I wrote a lot of memos for partners I was working for, and then later I had a lot of memos written for me by the junior associates. Another thing I agree with, if it's a well-written memo, a lot of my briefs to the court ended up coming from that.
Exactly. I'm not quite cut and paste, but not too far from it sometimes on a well-written.
Other questions?
Mr. Davis, I appreciate what you told us that the market was rejecting our product, because I took it as a challenge. But my question to you is that, is there, and it's two parts actually, is there an understanding of the students that are now entering law school at the end point of the marketplace? Meaning that, is there an understanding of that students are coming in with extreme deficits to law school? And so what the class that graduated in 1982 is not the class that's graduating in 2014, just in terms of what they had coming in the gate, right? The skill sets they have from their undergraduate education. And so that's the first part of the question, is there understanding of that? Second part is, so what, right? Like, is the market, do you think, willing to adjust or not? And then should we make adjustments in our admissions process to account for that? So that we produce a better product because we're getting in students that are
I don't know. Well, let's start with the proposition that the legal profession is, by definition, a conservative, slow-changing process, and the inputs hit maybe faster. The judges are still used to getting well-written, thought-out briefs and papers, and yet, at least by legend and lore, the millennials are, they've got multitasking and lots of things going on, and they don't focus on that. I'm afraid, though, that you're still going to have to play the cards you're dealt and try to convert them into the mold that we need. And I always try to at least take advantage of their new thought process, and are there ways that we can become more efficient, and just because we've always done it that way in the past is no reason to keep doing it that way. And the young people coming in were a great source of innovation and things that I like to do.
And I have if the question is whether, you need to change so that the law, big law is going to hire more people. I would look at it a different way, because it may be big law never does hire more people. And what I'm seeing in the last few years is a remarkable shift in the law graduates going out on their own. And so the emphasis of the importance of practice ready is not just to go into somebody else's firm, but it's to go into maybe your own firm, or maybe a firm that, with a bunch of young people, you've got energy, and just go into it, and, competing on, rates and finding their way, what they excel in and whatever. But that I think is very much a focus now. The model's shifting, and I'm very involved in the ABA and looking at trending on some of this, and my sense is that we're never going back to the way we were before, but that may not necessarily be a bad thing. So, that would be, I think, where the focus is for the practice ready.
That's very good. If I could pick up on that point, my son-in-law graduated law school, and he was really chomping at the bits to get out and start his own practice. He did work with a larger firm for 2 years, but then jumped out. And obviously, he needed a skill set that was different than my skill set, and that would have been very helpful if you had, law office management courses, and I've really thought about that. The other thing is, how could you take advantage of the advantage that a small, nimble law firm, we're beginning to hear, or I know you hear this all the time, that there are these small boutiques that are saying they'll do the work for half the price of Holland Knight or King and Spalding, and it's because they've got virtually no overhead. The people are working from home, and they're doing this and that. And I've said that law schools ought to be legal entrepreneurship. Could you teach that as a way to give people a different path that they're going to go? Because I agree with you. I think we're going to go back. There's such a glut of lawyers that big law firms do not need to hire people right out of law school now, and they're hiring only the
Just an anecdotal thing, what you just said about people going out and charging half the price and all that. I just talked to a recent grad who does appellate work, and that's what she's planning on doing. She has another, she wants to be in academia, so she's working towards that. But you can't have a full-time practice and a full-time academic life. They just don't mesh. There's not enough time in the day. And so she was thinking, instead of killing myself, what I'm going to do is just offer my appellate services for $150 an hour to all these people I met when I was practicing. And then I will have time. I can make money, and I'll have time to try to focus on getting someone to hire me for an academic job. And so that's just an anecdotal thing of somebody that I know personally who's doing that.
It was just a follow-up. Part one of my question though is really about who is coming to law school now. So I think I've taught at many different law schools, but at Mercer we get really good students. But at a lot of law schools where I taught, students are getting into law school and they don't have just basic skills. They don't have basic reading skills. They don't have basic writing skills. So to get them up to speed in 3 years is a very difficult and daunting proposition, especially when we're hearing from the bench and the bar, well, maybe we need to cut legal education. And those of us in this room usually start riding on around and saying, if anything, it needs to be another year, right? Because we just can't, and then the charge on top of it to make them practice ready when they're not even law school ready is another daunting task. So I'm wondering, any predictions across the board? What impact will this have on the delivery of legal services? Or, do law schools need to seriously adjust how we accept students? And that makes me a little nervous because I'm concerned about underrepresentation in the profession. I'm concerned about the students that we're getting in who may not have those skills, but would still be an asset to the profession.
I think the marketplace, I think the legal education marketplace is kind of taking care of that. We're hearing these drop-offs in the number of applicants and the like, and I think that's something that all law schools are going to have to just look at. You were scalable to go up, or you scalable to go down, and keep your quality, keep a smaller number of students. I think that's something.
But let me touch on that a little bit. I know what you're saying as far as some people going into law school are very much better prepared. My major in college was medieval French literature. It doesn't sound like it's real useful, but the matter of fact is that I was quite used to doing what they call the custom de text and really analyzing in and then writing. So for me, I was pretty ready, actually. But I have an associate who I just adore, who went to Mercer after a career of professional football. He played for Georgia Tech, and then he played some for the Giants, and I don't know his whole career. I'm not a big football fan. But anyway, he did. He was a professional. After playing football, he did work as an engineer before going to Mercer Law. And he's got fabulous analytical skills. But his writing skills were not, where mine were when I entered law school, So I'm working with him because I don't want to lose this guy who's a really cool guy, dynamic, engaging, clients, love meeting him. He does memos for me. And he always has a really good analysis, but, so I'm trying to train him. And so that there is, it's really important. I would emphasize what, Dwight and Kathryn have been saying though, and say, I think one thing that needs to be, the message needs to come across early in law school of, the importance of writing, how important it is, and Dwight, you were saying that, lawyers do writing all the time, and Kathryn, whether it's an indictment or whatever, emails, it's important to write a good email, and people don't realize that, and so we're getting a dilution of the, the erosion of the sensibility of writing and the sense of importance. It's going down, and the text, oh my God, it's like, and I even do it, and like, oh, who cares if it's, not spelled right, or, as long as they get, the gist. That's just not so in what we do. You have to be professional, and so there's kind of an attitude thing that, and we're fighting a tough battle. It's not just, a football player deciding to become a lawyer. It's everybody, and especially the younger people coming in with this, the culture of everything so fast, and it's a tough battle. But they have to understand how important it is to really to eventually win it, because the judges, whether they're, the old guys or newer, they want to see something professional. They want to, you need to have a professional, top quality work product, and writing is essential.
Jennifer, you had a comment?
Hi, I just wanted to build off of what you just mentioned about working with someone to get better at writing. That is exactly what I wanted to ask everyone. So on my darkest days, like my most sort of pessimistic days, I think maybe in law school and certainly in law practice, what's really happening is just sorting of people. Like people who can write really well get better assignments, then they get better assignments, and then they get better assignments, and people who don't write as well, people don't knock at their door as much. The quality of their assignments goes down, and then suddenly it's like awkward conversation, time to make a transition. So I really want to fight against that. I want in law school, I want to give the students as many tools as possible to get better and make a change. Like law school is the perfect place for, addressing things and, really accepting that you can get better as a writer, and for us to give the tools for them to do that, and not just to continue to stamp them good or bad or ABC or whatever. But in law practice, how can someone really make that change? Is it, to be pessimistic, is it just too late and they're going to be sorted and that's just life and we need to deal with it? Or, coaching story is wonderful, and I'm just, are there more like that, or is that the exception?
No, it's something I've thought about for a long time, and I've kind of, over the years, sometimes I've taken the path of least resistance and just gone for the ones that are good, and other times I go, no, we got to work with people on that. And right now I'm very much more in we got to work with people, because I'm not just head of the appellate team. I just made me head of the litigation and practice group in Atlanta. So I've got to deal with trial lawyers, and there may be techniques that work better for some people than others. I think the time management thing Kathryn mentioned is absolutely critical. People have to understand. You don't wait to the last minute and just write something. So getting people to impose on themselves and be disciplined enough to have deadlines for drafts, and to understand that it's a process of drafting is not something done just once. It has to go around. So if you make people do that and tell them to go back, I also think you can have templates for, everybody's got the little template for memos, but facts, issue, discussion, conclusion. But if you can break it down even more, and get people working on sequencing, and so I think that there are some techniques maybe in training techniques. And again, as I say, I want to learn from you guys on this, because it is very important to us in the private practice to make sure we can take advantage, because there's some people who are quite good at deposition taking. They're great in front of a jury maybe, but they just don't have that strong skill set. And I've struggled with that question, can you teach it? I think you can. I think you can help at least get people where they need to be as far as on the written side.
And we are almost out of time, but I just want to open it up to the panelists. Are there any parting thoughts or words that you want to leave with us this morning?
Stay at it. I don't know. I always try to tell when I'm talking with young lawyers that I had a terrific career. I thoroughly enjoyed it. I felt like I still to this day, I don't know if you graduate with a political science degree as I did. I did go in the Army for 4 years and came out. I don't know of another with that skill set where I could go in America today and make as much impact as I can make in this area. And it's still an honorable profession. It's still worth working at. And I'm reminded that when had been doing it for 30 years, I still felt like I was learning, which of course kept me energized. And why I say they still call it practice. You're still practicing. You're trying to get better all the time. And if you can infuse that idea into your students, that this is a 3-year process now, that's one phase of it, but you've got to continue to keep getting better at what you're doing.
Just briefly, to kind of piggyback about what has been talked about the marketplace. I know that the marketplace is adjusting, but I hope that the law school marketplace is adjusting too, as far as the students who are coming in have to be willing to actually want to do it, as opposed to I don't know what I'm going to do with the rest of my life, let me take the LSAT. So I'm hoping that adjustment is being seen as well. But as much as we're wanting a practice-ready lawyer and y'all are wanting a practice-ready lawyer, when they come out, some of them think that they're practice-ready and are not seeking out the advice. So I think the emphasis of finding a mentor, when we've shied away now as an office that we've moved along in the administration, we do not hire typically first-year lawyers. They go to a rural circuit or a misdemeanor circuit or something like that before they come there. And then when they come to the office, they're assigned a mentor, whether they want it or not. And I still believe some of them, we've had to go through that adjustment period of they believe they're practice ready to handle some of the big stuff. So as much as we want to have a practice ready lawyer and you want to make one, I think it's got to be emphasized that they've got to realize that it's still an evolving process.
And I agree. I think attitude is an important thing, and the message, and I think, to the extent that you can get people thinking and understanding the importance of this subject to success down the road, better opportunity.
Well, thank you once again.